Hi, my name is Abhishek and I'm a legal intern at LEXIS and Company. So today's my topic is experience and expertise in tribunal appointments GIRIJA VAIDHYANATHAN case. So let us talk about what is this issue. So the recent appointment of former IAS officer GIRIJA VAIDHYANATHAN as expert member in the southern bench of the NGT was challenged in the Madras High Court. So in this context, it is imperative to reflect on some of the principles behind the tribunal system. So let us talk about why were tribunals established. So tribunal function as a adjudicatory body in specific fields. The establishment of tribunals is based on the idea that specialization and expertise are required to decide complex cases of a technical nature. So the tribunalization of justice is thus driven by the recognition that it would be cost effective, accessible and give scope for utilizing expertise in the respective fields. So the central to this scheme is the principle that the experts appointed to these tribunals should bring in special knowledge and experience. So is the recent appointment is questionable? So let us talk about it. So the above criteria came under the focus with the appointment of GIRIJA VAIDHYANATHAN as expert member of the NGT. So the Madras High Court initially granted an interim stay on her appointment. So however, the court recently vacated the interim stay, stating that she holds the necessary qualification, and it ruled that she was not ineligible going by the criteria in the NGT Act. So she was found to have fulfilled the eligibility requirement by virtue of her administrative experience of nearly 5 years in dealing with the environmental matters. So let us talk about what does the Act specify. The Act spell out two kinds of criteria, based on qualifications and practical experiences, and second one is based on administrative experience in the field. So a candidate has to fill only one of them. For the first, a master or a doctorate in science, engineering or technology with 15 years experience in the relevant field is needed. This includes 5 years of experience in environmental and forest in the national level institution. So the fields include pollution control, hazardous substance management and forest conservation. So what is the ambiguous provision in this? So the administrative experience criterion lacks detail. It merely stipulates 15 years experience. On this, 5 should have been in dealing with environmental matters in either the center or the state or any reputed institution. So Ms. Girija's work as Secretary Environment and Forest, the Tamil Nadu, and chairperson of the State Pollution Control Board together amounted to only 28 months. So however, the court accepted the contention that her tenure as Health Secretary should also be considered. The court also observed that it is an entirely different matter whether the administrative experience in the second criterion should be regarded as equivalent to the real experts indicated in the clause on qualification. So the court rightly declined to interfere with the appointment as the equivalence found in the rule falls under the domain of Parliament. So what is the way forward from this? So the relevance and the composition of tribunals are under judicial scrutiny. The centre itself has abolished some of the tribunals. So given this, the government should spell out with clarity that the extent to which a bureaucrat's involvement in environmental matter could be regarded as equivalent to expertise. In other words, how far the experience can be treated as expertise for tribunal post. And it should also show greater urgency in implementing earlier Supreme Court directions to constitute a National Tribunal Commission, and this will supervise the appointment and functioning of the tribunals. So that's it. Thank you.